Welcome to the Deep Dive. Ever wonder how the government decides which substances are illegal and how that impacts scientific research? Today we're diving into a piece of proposed legislation called the HLLT Fentanyl Act, or HR 27. You might be hearing about fentanyl in the news a lot, and this bill, well, it aims to change how substances related to it are controlled.
That's right. Think of fentanyl as one specific key, and this bill is about creating like a master list that covers a whole bunch of similar looking keys that could also open the same, dangerous doors.
Our main source for this is the actual text of the bill, so we're getting straight to the source to see what changes it's proposing.
Exactly. Our mission today is to unpack what this bill would actually do, especially in terms of how these fentanyl-related substances would be classified and how that could affect things like law enforcement and the development of new medicines. We're going to try and explain this in a way that makes sense and shows why understanding something like this matters to you, even if you're in high school. It's all about understanding the roles that shape our communities. Okay, so at its heart, the HLLT Fentanyl Act is about something called class scheduling. Imagine the government has different levels of security for different dangerous items. Schedule is like the highest security level. This bill wants to put all fentanyl-related substances into this Schedule O of the Controlled Substances Act.
For those of you who haven't heard of the Controlled Substances Act or the schedules, what does it actually mean for something to be in Schedule N? Why is that such a big deal?
That's a really important question. Schedule N is reserved for substances that the government believes have a really high chance of being abused, have no currently accepted medical use in the U.S., and aren't considered safe to use even with medical supervision. Think of things like heroin, that's a Schedule I substance. Putting fentanyl-related substances there means they'd be under the strictest level of control.
So this bill is saying that these fentanyl-related substances are as dangerous and have as little medical use as something like heroin. That's a strong statement. But what exactly does fentanyl-related substance even mean in this bill? It sounds like it could cover a lot of things.
You're right, it's a deliberately broad definition. The bill goes into some technical detail in Section 2, but the basic idea is that it describes several ways a chemical can be structurally similar to fentanyl and therefore be considered a fentanyl-related substance. It's all about specific parts of the fentanyl molecule and what kind of changes or swaps can be made to those parts.
Okay, this is where it might get a little sciencey.
Yeah.
Can you break down what kind of changes we're talking about without getting too lost in the chemistry?
Let's try an analogy. Think of fentanyl as a particular type of building block. This bill says that if you take that block and change certain parts of it in specific ways, maybe you place one section with a block of a slightly different shape, or you add a few extra connectors to certain spots, it can still be considered in the same dangerous category. The bill lists several specific types of these block swaps or connector additions, based on the actual chemical structure.
So it's not just fentanyl itself, but a whole family of chemicals that are similar in structure. The bill mentions things like replacing the phenyl portion or changes to the phenyl group. Are these just different parts of our fentanyl building block?
Exactly. The phenyl portion and the phenyl group are specific parts of the fentanyl molecule. The bill says if you replace the phenyl part with any similar ring structure, or if you make certain substitutions on the phenyl group, like adding small chains of carbon atoms or elements like chlorine, or even certain combinations of atoms, it can fall under this definition.
Okay, even with the building block idea, some of those chemistry terms still sound a bit complicated. But the main takeaway is that it's looking at chemicals that are structurally like fentanyl, even if they're not exactly the same. The bill also mentions changes to the piperidine ring, the aniline ring, and the N-propionyl group. Are those more of our key parts?
Yes, those are all key structural components of the fentanyl molecule. The bill specifies that certain changes or replacements to these parts, again, involving the addition or substitution of different chemical groups or the replacement with similar ring structures, would also qualify a substance as fentanyl-related.
It really does sound like they're trying to cast a wide net, like our outline said, to catch any new variations that might pop up.
That's the core idea. The aim is to prevent people from creating slightly different versions of fentanyl that haven't been specifically outlawed yet. However, because the definition is so broad, the bill does include a few situations where a substance that might technically fit the chemical description wouldn't automatically be included in this new Schedule I category.
What are those exceptions? What kind of substances are we talking about?
Well, if a substance that meets the definition is already being controlled in a different way by the Attorney General, maybe through a temporary order, or if it's already listed in one of the other schedules of the Controlled Substances Act, Schedule 2, 3, Phi, or V, which are for substances with accepted medical uses and varying potentials for abuse, then it wouldn't be automatically lumped into this new fentanyl-related substances category in Schedule 1.
That makes sense. You wouldn't want to regulate something twice in different ways. The bill also mentions that the Attorney General can publish a list of substances that they believe meet this definition. Should we expect a long list of these chemicals if this bill passes?
The bill does give the Attorney General the power to publish such a list in the Federal Register, which is like the official record book for government rules and announcements. However, and this is a really important point to understand, the bill clearly states that just because a specific fentanyl-related substance isn't on this published list doesn't mean it's legal. If it still fits the very detailed chemical description written in the law itself.
So even if a new variation pops up that isn't on the list yet, if it chemically looks like it falls under the definition in the bill, it's still illegal under Schedule 1. That's a pretty significant power. Now, let's talk about how this might affect scientific research. Putting these substances in Schedule, I could make it really hard for scientists to study them right.
That's a very valid concern, and the bill actually has a whole section, Section 3, dedicated to trying to make research on Schedule I substances, especially fentanyl and its related substances, a bit easier. The people who wrote this bill recognize that while these are dangerous substances, we also need to study them to understand their effects, find ways to treat overdoses, and maybe even develop non-addictive pain medications in the future.
So how does the bill try to balance the need for control with the need for research? What changes does it propose?
It creates what it calls an alternative registration process for certain types of research involving Schedule A substances. This new process would apply to research on drugs that are already being studied for potential medical uses under an investigational new drug application. That's when the FDA gives permission to test a new drug in humans. It also applies to research funded by or conducted by major government agencies like the Department of Health and Human Services, the Department of Defense, or the Department of Veterans Affairs.
Okay, so if a scientist is working on, say, a new drug to reverse a fentanyl overdose, for example, this new process might make it easier for them to get the necessary substances for their research.
Exactly. For researchers who are already registered to conduct research with other highly controlled substances in Schedule 1 or Schedule 2, the bill sets up expedited procedures. This means they can start their research on a fentanyl-related substance relatively quickly, just 30 days after they officially notify the Attorney General and provide some key information. This information includes the specific chemical name and the amount of the substance they need, proof that their research falls into one of the categories we just talked about, like a grant number or that investigational new drug application number, and confirmation that they have the necessary approvals from their state to do this research.
30 days sounds a lot faster than what you might expect for dealing with Schedule I substances. What about researchers who are just starting out and don't already have those Schedule 1 or 2 registrations?
For them, the process is also sped up. When they send their notification to the Attorney General with the same required information about their research, that notification actually counts as their application to become registered for this research. The Attorney General then has a 45-day time frame to either grant them the registration or to issue what's called a show cause order, which basically explains why they might not be eligible for registration.
That's still a much quicker turnaround. The bill also mentions that researchers can submit these notifications electronically. That seems like a small thing, but it could probably save a lot of time and paperwork.
Absolutely. Making the submission process electronic should definitely make things more efficient for researchers.
Now, are there any limits on how much of these fentanyl-related substances researchers can have access to under this faster process? You wouldn't want researchers just, stockpiling dangerous drugs.
You're right, there are safeguards. Researchers can only have the amount of the Schedule I substance that they initially stated in their notification to the Attorney General. However, if the research needs change and they need more, they can submit an additional notification explaining why they need the extra amount and confirming that it's still for the same approved research project.
What about if researchers need to bring these substances into the country or send them out for collaborative research? Does this bill change the rules for importing and exporting?
No, the bill specifically says that this section focused on research doesn't change any of the existing rules and regulations for importing or exporting controlled substances. Those are still separate processes that researchers would need to follow.
The outline also mentions that there's going to be a report from the Inspector General. What's the purpose of that?
Right. Within 1 year after this act becomes law, the Inspector General of the Department of Justice is required to conduct a study and submit a report specifically on the research involving fentanyl and fentanyl-related substances that's being done under these new, faster procedures. This is likely to help the government evaluate how well the new system is working, identify any potential problems or areas that could be improved, and make sure the streamlined process isn't being misused.
That sounds like a good way to keep an eye on things. There are also some parts about researchers working within the same institution and at different research sites. Can you explain how the bill addresses those situations?
Yes, the bill tries to cut down on some of the red tape for research institutions. It says that if one researcher at a university, for example, is already registered to conduct research with controlled substances in a certain schedule, other qualified people working at the same institution can work under that existing registration, as long as they're working within the scope of their job and the registered researcher gives them permission and takes responsibility for their work with the substances. The registered researcher does need to inform the Attorney General about these additional researchers, and the Attorney General has a short period to object if there are concerns.
So it's like a lead researcher can oversee others in their lab without everyone needing their own individual registration. That could definitely make research projects run more smoothly. What about if a university has research labs in different buildings or even different parts of the same city?
The bill also allows researchers to use a single registration for multiple research locations, but there are a couple of important conditions. First, all the research sites have to be within the same city or county, and they all have to be under the control of the same institution or organization. Second, the researcher has to notify the Attorney General about each specific location before they start doing research or storing the controlled substances there.
That would be really helpful for institutions with multiple facilities close by. It simplifies the paperwork, and it looks like the bill also says that if a researcher wants to study a new substance, they might not need a whole new inspection.
That's right. If a researcher is already registered and has been inspected for working with controlled substances, and they want to add another substance in the same schedule or even a more tightly controlled schedule, the bill says that usually they won't need to go through a completely new inspection of their lab. This can save time and resources, although the Attorney General still has the authority to conduct an inspection if they have reason to believe there might be security issues or a risk of the substances being diverted for illegal uses.
There's also a section about what happens if a substance a researcher is already studying suddenly gets added to Schedule I because of this new law. It sounds like they want to make sure that important research can continue.
Exactly. If a researcher is in the middle of studying a substance and this act suddenly classifies it as Schedule I, and the researcher already has a registration to do Schedule I research, they get a 90-day window to submit a full application or modify their existing registration to include the new substance. And importantly, they can continue their research on that substance during this 90-day period while their application is being processed, unless the Attorney General steps in with concerns. This prevents research from being abruptly halted due to the change in classification. Plus, if the researcher shows proof that they've applied to study the substance to a company that makes or distributes it, that's considered enough proof that they're allowed to receive it.
That's a really smart provision.
Yeah.
You wouldn't want important scientific work to just stop because the legal status of a substance changed. And it looks like the bill even covers some of the basic things researchers might need to do with these substances as part of their work.
Yes, this part acknowledges that sometimes researchers need to do things like create extracts, make solutions, or even develop early forms of a drug, like a pill or a liquid, in small quantities as part of their research process, especially when they're looking at potential new medications. As long as these activities and the amounts involved are clearly described in their research plans and are only for research purposes, the bill says they don't necessarily need a separate registration for manufacturing. However, there's a specific exception here. This doesn't give anyone the right to grow marijuana.
That's an important distinction to make.
Yeah.
Okay. Finally, in the research section, it talks about transparency. If the government decides to handle research applications for certain substances differently, what does that mean?
This provision says that if the Attorney General decides that applications to research a particular controlled substance in Schedule I should be reviewed using a different process or different rules than what's normally used for other Schedule I substances. They have to make that information public. They need to announce which substances are being handled differently, what the special process is, and why it's different. This information has to be posted on the DEA's website even if no one has actually applied to research that specific substance yet. This is all about making the process clear and, fair for researchers.
Okay, moving on from research, it looks like the bill also changes the penalties for dealing with fentanyl-related substances. How does it do that?
Right. The bill amends the parts of the Maine Controlled Substances Act and the Controlled Substances Import and Export Act that deal with penalties for drug offenses. It basically adds fentanyl-related substances to the list of substances that carry the same severe penalties as fentanyl itself and fentanyl analogs. Those are substances that are already treated legally as being very similar to fentanyl. So if you're caught trafficking large amounts of a fentanyl-related substance, you would face the same tough legal consequences as if you were dealing with actual fentanyl.
So it's saying that these new fentanyl-related substances are just as serious in the eyes of the law as fentanyl itself when it comes to illegal distribution. That seems like a pretty direct way to try and stop people from making and selling these drugs. And it looks like they're also adding a formal definition of fentanyl-related substance to the main part of the Controlled Substances Act.
Yes, Section 6C of the bill officially adds the detailed chemical definition of fentanyl-related substance that we talked about earlier, the one that's used for putting them in Schedule 1, to the general definitions section of the entire Controlled Substances Act. This makes sure that the term has a clear and consistent legal meaning throughout the law.
There's also a quick mention of something called a sense of Congress related to a court case. What's that about?
The sense of Congress in Section 7C is basically a statement where Congress expresses its opinion or agreement on a particular issue. In this case, Congress is saying it agrees with how the Controlled Substances Act was interpreted in a specific court case called United States v. McRae from 2018. This likely reinforces a certain legal understanding of how the law should be applied to controlled substances, although the bill doesn't go into the specifics of what that court case was actually about.
Okay. Finally, let's talk about how this whole act would actually get put into practice if it becomes law. It looks like the Attorney General has a deadline to issue some rules.
Yes, Section 5 of the bill outlines the process for creating the regulations to implement the new law. The Attorney General is required to issue these rules within 6 months of the act being signed into law. What's interesting is that these initial rules can be what are called interim final rules, which means they can go into effect almost immediately without the usual requirement of a longer public comment period beforehand.
So the new rules could be in place pretty quickly after the bill passes. But does the public still get a chance to have their say?
Yes. Even though the initial rules can be interim, the bill says that the Attorney General still has to give interested people the opportunity to provide feedback and even request a hearing on these rules. After considering all of this input, the Attorney General will then issue the final official regulations, following the standard procedures for making rules.
But even before those final rules are in place, when would the actual changes from this act start to have an effect?
Section 7A is very clear on this point. It states that no matter when the final rules are officially published, the changes and updates made by this act will be in effect starting on the exact date that the act becomes law.
That's important to know. The new classifications and the faster research procedures would start as soon as it's signed. And there's one last thing mentioned: a rule of construction. What does that clarify?
The rule of construction in Section 7B is basically a legal clarification. It's saying that just because this new act is specifically addressing fentanyl-related substances, it shouldn't be interpreted to mean that these substances weren't already considered to be similar to fentanyl under the existing laws before this act is passed. It's trying to prevent any legal arguments that might try to say these substances were in a legal gray area before.
So to sum it all up, the HALT Fentanyl Act is really trying to get a handle on the problem of fentanyl-like substances by putting them all under the strictest level of control, while also trying to speed up the process for scientists who want to research them. It also makes sure that the penalties for dealing with these substances are just as tough as they are for fentanyl itself. And it sets a timeline for the government to put these new rules into action.
That's a great summary. The key things for you to remember are the very broad definition of what counts as a fentanyl-related substance, the significant changes aimed at making research easier, and the fact that these substances will be treated with the same legal seriousness as fentanyl when it comes to penalties.
So for our listeners in high school, thinking about your communities and the news you might be seeing about the opioid crisis, how might these changes in the law potentially impact things? How might it affect efforts to prevent addiction or develop new treatments? It seems like there are potential positives and, well, negatives to consider with such a broad approach.
That's a really important question to think about. On one hand, making these substances illegal and imposing strict penalties could help to reduce the supply and hopefully prevent some of the harm they cause. On the other hand, the very broad definition could have unintended consequences, and while the bill tries to streamline research, it's worth considering whether these changes will be enough to really accelerate the development of new solutions to the opioid crisis. It's a complex issue, with a lot of different angles to consider.
If you want to dig deeper into this, we encourage you to check out the actual text of the Controlled Substances Act and maybe even follow the progress of the HALT Fentanyl Act as it moves through Congress. Understanding how these laws are made and what they aim to do is a really important part of being an informed citizen.
Absolutely. And thinking critically about how laws like this might affect different parts of society is a valuable skill.
Thanks for taking this deep dive with us today. We hope this has given you a clearer picture of what the HALT Fentanyl Act is all about and why it matters.